trying 16-year-olds as adults, it can be a no-brainer in some cases, but did you know in only 2 states are all 16 and 17-year-olds treated as adults in the eyes of the law? I bet you any amount you'll never guess what the 2 states are. First one's North Carolina. The other, New York. That surprised me at least. Give a practical consequence where a 16-year-old and an 18-year-old, there is a material difference, or should be.
There's a material difference. I mean, it's well established that the brain doesn't fully develop, sometimes even into the 30s, early 30s.
Yeah, look at me.
See, I wasn't going to say that. But certainly when you stop and look at the fact that young people are impulsive, you're going to find that they're going to get involved in things that they wouldn't do. How often have you talked to someone and the person says, gee, I'm a very different person than I was as a teenager or in my 20s? And what we're doing right now is we're taking young people, we're putting them in situations where they're not mature enough yet to make the decisions. They don't have a right to have a parent available when they're being questioned by police. And once they get into the criminal justice system, it's something that's going to stay with them forever. We were talking about it earlier, and we were talking about the fact that federal courts may even use your youthful offender, even though it's not technically a conviction, it's a nullity, can use that against you for criminal points, criminal history points in federal court.
How does it work in other states? Is it discretionary, depending on the severity of the crimes, to treat the person as an adult or a minor? Or?
Most of the other states actually set a plateau, and they say that if you're under a particular age, most of them are 18 years old, that you're going to be treated as a minor. The thing that's significant
Even
is...
if there's murder and stuff?
Well, a lot of states will have a different rule for murder, and that's the extreme. But when you look at the cost, normally if you have a young person in jail, you're spending much more money for that person to be housed because they're not going to be in general population. So you could spend $100,000 a year for a young person to sit in jail.
No matter what, the kid's not going into an adult facility till 18, right?
That's right.
So even if they're sentenced at 16.
Absolutely.
When you have these either clients or you've prosecuted these folks, can you tell the difference from a 16-year-old and an 18-year-old?
Absolutely. I mean, if you have kids, you can tell the difference, right? I mean, people mature. I mean, the reality is I asked a few friends of mine that are judges, and they said, yeah, I know, but why do we have to change the law? You know, a judge can always, you know, you can make a pitch to a judge and they can make the decision. I don't know if that's right or wrong. I mean, but
do judges have discretionary powers at sentencing here? If they're 16, or do they have to treat them as an 18-year-old?
If you're over 18, you can't be treated as a youthful offender. Most of the time, they will have no discretion. Occasionally, if you have a prior conviction, you can be a discretionary youthful offender. But for the most part, what you find is that once you put a person in the criminal justice system at a young age, the chances of them reoffending are greatly increased. You end up spending, you could spend $5 million on one individual. And when you look at the amount of money we spend over a person's lifetime.
$5 million.
Well, and think about that's just the cost of actually dealing with them in the criminal justice system. It ignores the fact that they're less likely to contribute in a meaningful way on their own. So they're not going to contribute to the economy. They're not going to be able to raise their own families well. All of these things.
I want to switch gears to an issue that, you know, as a layperson, we always wonder about, but you guys have probably dealt firsthand. The idea of cooperating witnesses. Is it real, Doug, that I could do the worst crime, let's say, with 2 other defendants here, and if I flip first on the other 2, I could walk while they'll see real time?
Well, listen, I know Jim and Mark are the Mayo or the experts on this a little more than me, but I'll take the other side. I mean, listen, I think these crimes don't occur with a bunch of altar boys around usually, and so things have to happen. So I think prosecutors sometimes have to make that deal. They have to make the decision. My only thing is that the guy at the bottom can get the deal. He's perceived at the bottom, where the guy at the top, he doesn't get the deal. And I think there's an inherent unfairness there, but I'm sure you guys have a...
There's an unfairness in many ways. Look, Doug, I agree entirely. There is a value to cooperating witnesses. Crimes, especially organizations, they operate in secrecy, and sometimes you need somebody from the inside to reveal those secrets. The problem is that the system is being turned inside out. You've got kingpins who cooperate because they have the information. It's their business. They know who else is out there doing whatever. The minions, the mules, the people who purposefully are kept out of the loop, they don't have the information. They have nothing to offer. We have mandatory minimums of 10 years in jail for certain narcotics offenses. Some of these minions, some of these mules, they can't get around those. So you have situations where the kingpins, the larger players, are getting the deal because they have the most to offer.
Okay, put on your prosecutor hat, though. If you don't have guys that'll be cooperating witnesses that will rat out, how much does that grind the system to a halt when you're trying to bring down a cartel or something else?
Well, it depends on how serious you are about your investigation, especially if you're talking about white-collar cases. There's a paper trail. So you're not talking about a drug case where you're trying to figure it out. And even in drug cases, normally if you do some due diligence, you can figure this stuff out. The thing that always amazes me is the people at the very top who don't get charged at all. Or if they do get charged, they've stolen almost $1 billion and they get a deferred prosecution.
Yeah, well, we've seen that with SAC Capital. I mean, we don't have the principal culprits being charged. It seems to me that the practice of using cooperating witnesses is age-old. It's not going anywhere. A federal court out west ruled it unconstitutional 10 or 15 years ago. It was promptly overruled. But there are ways that you can mitigate the harms that can flow from the use of cooperating witnesses. For example, in federal court, the uncorroborated testimony of one snitch is enough to convict somebody. Not so here in New York. There has to be a degree of corroboration for the accomplice, a slight degree, but some corroboration nonetheless, and there could be a legislative fix, for example, passed by Congress or the Supreme Court in its rulemaking authority requiring some quantum of corroboration. There could be a rigorous jury instruction given that these people have a huge incentive to fabricate charges, and you could scrutinize their testimony very carefully, much more so than you would a normal witness. And those are some ways that you could protect a defendant.
And that's the other half. Go ahead.
I want to ask you something real quickly,
Sure.
because you've had some high-profile client in the form of Mr. Gotti here that this may apply. We've seen now, obviously with OJ, and again, you can even see potentially here with Mr. Zimmerman in Florida on an unrelated charge, obviously the stand your ground. Subconsciously, or maybe you'd argue consciously, when a judge gets a chance, even if they weren't the original judge, to have that client in front of them for an unrelated thing, and they think they didn't get it right the first time, is it a lot harder when you're defending this client?
Look, OJ went to, and I'm not defending the guy in any way, but he went to recover his own stuff, albeit, let's just accept the conviction with a bunch of thugs, and maybe a couple of them were armed. He got 9 to 33 years
well,
for it, fellas.
Punishing him for knocking all over those Hertz things.
Exactly.
And that's well deserved.
So, I mean, does that not answer? 9 to 33 years, fellas. What's he getting? Let me ask you this. What's he getting if he's OJ without the prior trial?
Yeah, but look at Sammy
getting
Gravano.
probation.
He's getting punished for...
When we come back, I want to ask these
right.
guys here, they've all seen the legal shows, LA Law, Perry Mason, The Good Wife, whatever. What drives them crazy when they see the same shows we see on TV, like Law & Order? What's real and what's not? We'll be right back.